Hi, good morning. This video is for the students who have just come into the legal field and they are scared of some of the legal terminologies which are being used in law. This will be applicable to both CS students, people who are pursuing company secretary course, and also people who are going to appear for CLAT, which is the entrance test for law, and maybe even the first year students of law refer to this video for understanding what these legal terminologies or maxims really mean. So the first one today is ab initio, which you might have heard earlier as well. Ab initio basically means from the beginning. So some act was invalid ab initio. Or maybe I can give an example like an agreement with a minor is void ab initio. As in, if you enter into an agreement with a minor, it will be considered as invalid right from the beginning. Second is actio mixta. Actio mixta. So this means mixed action, which is there is certain mixed action which is being taken against the people, which can be considered as actio mixta. Next one today is actus reus. It is a commonly used terminology which means wrongful act. Next one is ad hoc, which is quite common and which means ad hoc. There is an ad hoc inquiry, which means for the particular end or case at hand. So generally we use this term in reference to the committees which are set in case there are certain mishappenings in the country. So an ad hoc committee is formed to take care of the details of the case. Next one is ad valorem. Now this terminology was generally being used in case of customs duty. Ad valorem duty used to be levied on the products. So ad valorem is according to value. So based on the value, this duty will be levied or on the product. Next is benami. I get a lot of questions from students who have studied in English medium, and although benami is a very common Hindi word, a lot of students come to me asking what is exactly benami. So benami means nameless. It's a simple meaning. It means nameless. Benami, bina naam ka. So benami transactions. This is how you can come across this terminology, benami transactions. Next is again a very common term. It is bona fide. So bona fide, we generally use this term in reference to the certificates. So bona fide certificate. Please send us a bona fide certificate of your degree. So it is called as good faith or genuine, something which can be considered as genuine. Next is again a very common terminology used generally with reference to buyers and sellers. So this is caveat. Caveat emptor. So this is again this was there under Sale of Goods Act. For the first year law students, or also even if you are pursuing CS and you are at the executive level, you might have this act called Sale of Goods Act, and in which we have caveat emptor, which means let the buyer beware. So this is also a very common terminology. Next one is certiorari. Now there is a lot of discussion over what exactly or how exactly we pronounce this word certiorari, or the way I was taught some 30 years back, it was certiorari. So I definitely don't recommend calling it certiorari. It is called as certiorari, and also you can check it on Google, the pronunciation, exact pronunciation for this word. The spelling goes like CERTIORARE, and it is called as certiorari, which means a writ by which records of proceedings are removed from inferior courts to high courts and to quash decisions that goes beyond its jurisdiction. So generally it is taken by the inferior courts in case the proceedings have to go from the inferior courts to the high courts. So some matter which high court feels that it has lot of substance, lot of value, then they may ask for the proceedings of this case, and it is called as certiorari, wherein the proceedings go from they are removed from the inferior court and they go to the high court. Also in certain cases, if high court feels that the decision which was given by the district courts or the inferior courts is not right, in that case also this will be applicable. Next one I would like to discuss today is okay, there is a simple term called damnum sine injuria and injuria sine damnum, which is again part of Sale of Goods Act, which means damage without injury or injury without damage. To understand this better, I think we will have to go a few. We will have to see the few provisions under Sale of Goods Act to understand this. Or sorry, not Sale of Goods Act. It was falling under the Torts Act. Next is de facto, the simple meaning for which is in fact. So de facto, it's a commonly used terminology. Next is de novo. So again, de novo is something which we used with reference to certificates, and basically it means to make something new or to alter. So we can get a de novo certificate for certain things or de novo registration for certain things, which means to make it new. Let me see what else is there. There are certain terminologies like ejusdem generis. So what exactly does ejusdem generis mean? Ejusdem generis means where there are general words following particular and specific words. The general words must be confined to things of same kind as those specified. This is the exact meaning of ejusdem generis. There is another common word which is being used as estoppel. So stopped from denying. So the person is stopped